Hello, my name is Scott Goldschmidt, and you're listening to Higher Education Grants in 2025, Lessons, Updates, and Future Outlook, which may be one of the last webinars of 2025 for the Thomson-Coburn Higher Education Series. For those not aware, Thomson-Coburn is a full-service law firm with over 400 attorneys in offices across the country. Important to this webinar, we do have a higher education practice, which is a group of attorneys that dedicate all or most of their time to serving institutions of higher education and the education industry. As people are jumping on, we want to cover a few housekeeping items. First, if you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We'll try to answer these through the webcast, but if a more complete answer is needed, or if we run out of time, we'll try to answer it later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download it and any resources or links you may find helpful. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen. If you experience any technical problems during the webinar, those can also be reported using the Q&A widget. Today's presentation is CLE accredited in California, Illinois, and Texas for 1 hour of general credit, Missouri for 1.2 hours of general credit, and in New York for 1 hour of professional practice credit for experienced and transitional attorneys. We award CLE credit based on attendance for the entire 60 minutes. As required, we'll display secret words in 2 multiple choice polls during the presentation. You'll be required to select the secret words from multiple choice list. Please respond to these polls to demonstrate your continued engagement and to earn your full CLE. We value your opinions and appreciate your participation in this course. All right, to the preamble, a few more notes. So first, as you know, laws and policies are updated regularly and litigation is fluid. If you're reviewing this presentation after December 2025, please keep in mind that changes may have occurred. There are live links throughout the presentation. Please feel free to use them. And finally, all TC resources referenced in the presentation are free and can be accessed here on the slide or by scanning the QR code to the right. We'll go through in detail those resources later in the presentation and are happy to provide this service to the higher education community. All right, housekeeping over with to the actual presentation. We have a few fantastic presenters. Not only have these individuals been closely tracking all the latest development in the grant world, which is no small feat, but they've also been advising scores of institutions and associations on these issues and litigating in court on their behalf. Brant Hill and Alex Spanos reside in their Birmingham office. They're higher ed litigators through and through. Their practice is focused on defending institutions in high-stakes litigation and advising them how to comply with the complex and ever-changing Department of Ed regulations. Jana Russ resides with me in our DC office. She's a government contracts attorney and advises recipients and awardees of federal grants, contracts, loans, and other financial assistance and represents them in litigation involving claims and bid protests. And as you might imagine, a significant portion of Jana's practice, particularly this year, has been focused on higher education. As I said in the beginning, my name is Scott Goldschmidt. I'm a higher education attorney, formerly in-house, and now focus on providing regulatory and day-to-day advice for institution. My role here is to set up the presentation and get out of the way so that Jana, Brant, and Alex can provide their insights. So here, this presentation is an hour long. It's going to focus on a recap of the grant world in 2025, lessons learned, and thoughts on future outlooks. But if you need a primer on government grants, you're in luck. We did that presentation back in April. That presentation, as with all TC presentations, is available for your review on demand. You're most welcome to review it in our YouTube channel or just click the QR code if that might be of interest. So today we're going to divide our presentation to 3 main buckets. First, I'm going to go through just why 2025 matters, what happened, what's all the deal, why we have this presentation. Jane is going to get into detail on compliance requirements and challenges, and Alex and Brant are going to go through grant litigation. And again, at the end, we'll kind of go through our TC resources in case you're looking for them and need them. So with that, right, why do we care? Why does 2025 matter? Well, if you're tuning into this webinar, you're probably well aware that 2025 was, and I guess still is for another couple of weeks, an unprecedented year in the grant world. As I said, Jana, Brant, and Alex are going to go through this in detail. But institutions this year have had to navigate federal policy shifts that reshape the landscape of grants, shifting federal priorities, funding threats and disruptions, heightened scrutiny of institutional practices, particularly with DEI, and escalated enforcement, right? Grant terminations, withholding or canceling of grants, as we've seen in the news for a lot of significant institutions of higher education. Also, False Claims Act risks, right? And Jane is going to go into detail about the penalties there, and slow and sometimes contradictory case law developments, as Alex and Andrew are going to go through in detail. So, by way of example, right, this is just last week. Department of Education put out a press release on their approach to awarding $208 million in new grants for mental health. In that press release, they wrote that they non-continued over 200 school-based mental health and provider grants earlier this year, that, this is their quote, placed ideology above serving students and included priorities out of line with the Trump administration. So as you see on the slide, those reasons for non-continuation included explicitly using racial preferences, requiring training that promoted discrimination, spending taxpayer dollars for DEI certificates, or practicing racial quotas in staffing and recruitment, right? And so this is all the department's rationale, but really important for institutions to be aware of this. This is the criteria, this is the public criteria, right, that the administration is using. And so finally, these unprecedented changes have led to a number of issues for institutions, right? Financial strain based on these unexpected termination of grants, the compliance chaos of trying to figure out rapidly changing rules, and administrative staff facing heavier workloads that they haven't before, and operational uncertainty, right? The shifting priorities and enforcement trends disrupted long-term planning and made this grant process relatively unpredictable. Okay, so hopefully you're all set, a really optimistic setup. I'm going to turn it over to my friend and colleague Jana to walk you through the details to see what's happening on the government grant side.
Great. Thanks, Scott. I am going to be talking about some of the new compliance requirements and challenges. Whenever we were building out this webinar, we were talking about, some of the things that you all might be interested in. And one of the things that I wanted to keep in mind is that depending on what type of school you're at, you may have grants from a variety of different places. You may have a number of different grants from the Department of Education, but also may have grants funded by the Department of Justice, funded by Department of Defense, especially if you have research grants at your university. So there's a whole host of different agencies you may be working with. And so I've tried to frame this section from the perspective of a school that may have a fair bit in Department of Education funding, but also that may have grants from other entities within the government. And one other thing I did want to add, I know at the beginning we were talking about, just in the general administrative things that we say when we do CLEs, that if you're viewing this after 2025, that things may have changed. I'll be honest, if you're viewing this after Wednesday, the 17th, 2025, things may have changed, because we're seeing some things take a long time in this administration, and then we're seeing some things move very, very quickly. So I do note, if you are watching this on a delay and not today, certainly make sure that what you're hearing today and reading is up to date, which of course you always do, but just wanted to add that in there. So I'll start by talking just very briefly about some of the things that I'll be mentioning in the next 20 or so minutes. Really, a lot of my focus is going to be how agencies have been implementing executive orders that may have an impact on grants in higher education. The 5 that I've listed here are the 5 that have seemed to come up the most from my communications with institutions of higher education. I won't be referring to these executive orders by the full name that the president assigned them when he issued them, but I put them here so that it's a little bit easier for you to find. But I am going to go through them in numerical order, which means chronological order, just because I think that can help you also see a little bit of how the trends have been moving, and there's a couple of ways that that might help as we discuss things from a grouping perspective. So the first one that I'm going to talk about is an executive order that the president issued on the very first day that he took office. This was an executive order about gender ideology. And it really was an executive order where the president put forth his view that the US should have a policy that there's only two sexes and that they are male and female, and that this needs to govern a lot of executive functions. As relevant to grants, the third major bullet is where we were starting to see some questions come in, especially for higher ed grant recipients. That third bullet is the executive order prohibited federal agencies from using funds to promote gender ideology, and also required those agencies to assess grant conditions and preferences, grantee preferences, to ensure that the funds are not promoting gender ideology. So this was one of the very first things that we saw agencies quickly trying to address. And I say agencies because one thing I do want to remind folks of is that executive orders are not laws. They are typically, in the grants and contracts world especially, directed to agencies, and then the agencies have to implement them. And so because of that, and because agencies are implementing them, we do see a variety of how that implementation occurs until or unless there is some kind of broader approach to addressing them. That broader approach usually comes from the Office of Management and Budget, which is part of the White House and helps guide some of these decisions. But we're still waiting on a fair bit of guidance so that entities have a bit more consistency in what to expect from the administration. But to give you an idea of how the executive order has been implemented, I pulled a solicitation sample term, and this was pretty early on in the administration. This was early in the summer, I think, whenever I pulled out this solicitation term. But this is how agencies were starting to try to implement this requirement early on. That said, as I inferred on the last slide, the implementation really did vary across agencies. To be honest, it even varied within agencies. So you weren't seeing consistent certifications coming out. Each certification differed by solicitation in many instances or by agency. And this is just one example. This is not something that is consistent amongst agencies. So then I'm going to move on to another executive order, and then we're going to come back and talk about certifications generally. But the next executive order that came out and really started to impact institutions of higher education was a January 31st executive order that aimed to address discrimination and DEI, so diversity, equity, and inclusion. One of the things this executive order did was rescind another executive order from President Johnson's time period, so one that had been around since the 60s, and that President Trump had allowed to continue on during his first term. But this executive order, 14173, directed agencies to include terms in grants that require grant recipients to agree that compliance with the applicable federal anti-discrimination laws is material to payment under the False Claims Act. And we're going to talk about the False Claims Act a little bit as well. They also have to certify that they do not operate any programs promoting DEI that violate federal anti-discrimination laws. There were also then requirements for the Office of Management and Budget, which I mentioned earlier, to remove references to DEI from a number of documents, including federal grants. Before I do move on, I did want to say that I think a lot of folks view this executive order as changing the landscape in the US as far as the approach to DEI. My personal view though is that it really just hit the fast forward button for those issues. We were already starting to see DEI programs successfully challenged in court following the Students for Fair Admissions decision from 2023. We were starting to see schools asking about changes they needed to make to their DEI programs following that decision. So we were already starting to see a slow roll out of changes to DEI programs. But the potential risk was a lawsuit from a class action perspective. And schools, I think, were reacting a lot more slowly than what we are seeing now, because this executive order has really hit the fast forward button on those issues by imposing the potential for False Claims Act liability. And part of how the administration is able to do that is by having a certification that grant recipients have to sign. I've put, again, another sample up here. This is one that was also from early in the summer. And part of why I use this one is I think it's a pretty good example of what I had seen from a number of different agencies. It's not one that is probably used by a lot of institutions of higher education. This is from the Federal Transit Administration. But I think the wording is very similar to what I started to see agencies doing later in the implementation of this executive order, essentially requiring entities to make these certifications and referencing that executive order when they make these certifications. So as I mentioned, I did want to spend a few minutes talking about the risks related to the certifications, because it's something that we have seen institutions of higher education have to address. They've started to address it, or they already have, or they know they need to address it now or sometime in the very near future. But the whole reason that these certifications are a big deal is because it imposes the potential for False Claims Act liability. There's the False Claims Act and then the Administrative False Claims Act. And I think when most people think about the false claims issues, they're thinking about the False Claims Act. Administrative False Claims Act, in all honesty, hasn't been used by a lot of agencies that typically fund institutions of higher education. It often has been used by HUD, the Housing and Urban Development, and SBA, Small Business Administration. So not to government agencies that fund a lot of higher education grants, but it is still a tool that agencies have at their disposal. And there were updates to that law recently to make it easier for agencies to use. And by recently, I mean under the Biden administration. So this may be a tool we start to see agencies use even for small dollar values. But the big issue most folks are concerned about is the False Claims Act. And that's because that can create up to 3 times the government's damage, plus up to $30,000 in penalties per invoice or a reimbursement request. Government damage, depending on when the certification happened and whether or not it was related to a specific payment request or if it was related to obtaining a contract or grant in general. We have seen multiple efforts by the Department of Justice over the years asserting that if there was a false certification made in order to get an award, that it will be 3 times the government's, 3 times the award. So not just an individual invoice, but it could be significant if it is a $10 million grant. That could be how the government at least argues its damages under the False Claims Act. And part of also why folks are asking questions about this, I'm going to actually start on the right side of the slide, is because it could be the Department of Justice who raises a concern. It could be the awarding agency. So if you have a Department of Defense research grant, it could be them, or it could be Department of Education, or it could be a disgruntled employee. It can be anybody under what's known as a qui tam lawsuit, and that anybody is the relator. They can bring a lawsuit alleging these false claims, and they're incentivized to do that. They will get a portion of any recovery that the Department of Justice receives. So any person who thinks that an institution of higher education has made a false claim to the federal government, they have a financial incentive to try to take that to the government's attention. And then the basis for liability is something that I think is starting to become a focus in how institutions of higher education are approaching these certifications. Because under the False Claims Act case law, the liability can come in one of three ways: actual knowledge, reckless disregard, or deliberate ignorance. Which means that a university or college or other institution of higher education, they don't have to just know that they were discriminating in violation of the law, but that would be the actual knowledge. They may have reckless disregard for that knowledge of the violation, or deliberate ignorance. And under those standards, reckless disregard means the entity was conscious of a substantial and unjustifiable risk that their claims are false, but submit the claim anyway. Or deliberate ignorance occurs when a person is aware of a substantial risk that their statements are false, but intentionally avoids taking steps to confirm the statement's truth or falsity. So really, these standards mean that an institution can't just ignore risk, and they have risk if they just bury their head in the sand and don't take steps to confirm whether or not the statements they're making in these certifications is accurate. And so what we are starting to see is questions about what the organizations and persons should be doing or know when they sign these certifications. This slide just kind of goes through some of the pieces of information that is helpful to have documented in the event that this certification is ever challenged. So the next executive order I want to mention is Executive Order 14187. This is an executive order relating to gender affirming care. It is mostly going to be important or relevant to institutions who have a medical school. And that's because under this first bullet, agencies have to take a look at their research and education grants to medical institutions, which includes medical schools, to ensure that those institutions are not receiving federal research or education grants and participating in chemical and surgical mutilation of children. And there's questions of what chemical and surgical mutilation may involve. There's questions about how far those statements reach, especially given the administration's approach to other aspects of gender affirming care. We are starting to, or we have seen that medical schools also have questions about how to deal with this in the context of standards of care that exist for medical providers. So there's often, to answer these questions and to make certifications relating to this, there's often a lot of coordination between departments within a medical school that may not normally need to coordinate. There's the program side, the grant side, and the provider side. And the providers aren't always able to provide to give their grants team as much information as the grants team gets from other departments that they work with. So this is something where we're seeing a bit of a I don't want to say a struggle, but it's a bit more challenging for medical schools to address than some of the other executive order questions that have arisen from their funding agencies. The next executive order that has come out that has been having an impact on institutions of higher education was one that was really directed a lot at the education world. And when it first was issued in February, I don't know that it got a lot of attention in the education world, but I put this information up here because it is going to be important when we talk about how the Department of Education has implemented this. But this executive order directed agencies to make sure that any programs that are subject to PERORA, is what people call it these days, I guess, the Personal Responsibility and Work Opportunity Reconciliation Act, that the institutions are complying with the requirements of that statute, which means that any, under the statute, alien who is not a qualified alien is not eligible for any public benefit. And a public benefit specifically includes post-secondary education provided to an individual. So that was issued in February. And then in July, the Department of Education issued some notices regarding its implementation of that executive order. And when it did that, the agency, the Department of Education, rescinded an older Dear Colleague letter. The Department of Education said that Dear Colleague letter had incorrectly classified certain programs as not subject to PERORA. So basically, the new Dear Colleague letter issued by the agency made certain programs specifically subject to this statute. And it also put forth the agency's position that a lot of, or vast majority of, post-secondary education programs authorized under the Higher Education Act are federal public benefits, meaning that institutions cannot be providing these benefits under these grants to persons who meet this definition of a non-qualified alien. The Department of Education's notices did not put forth specific verification processes or procedures. And it even said that grant recipients have no obligation to report on verification to the department. So this left open a lot of questions for institutions of higher education. And we have seen schools really figuring out how to address these requirements, really focusing on when they need to have documentations, when they need to maintain them, if they actually do need to, or if they can just rely on a review of the documents in the first place and documentation reflecting that somebody had reviewed them. There's a number of different questions as to how to implement this in the various programs. And we've also started to see schools questioning their processes to make sure that even if they had always been subject to PERORA, that they have been maintaining documents that they feel like is going to be supportive of their position in the event there's ever a Department of Education audit of those documents. And I'll be honest, having worked with folks on this myself, I do think that, you know, this is something that requires coordination amongst the grants team at a school and the HR department and others. Even if the entity or the persons receiving these public benefits are not employees, I mentioned the HR team because you need people who are familiar with immigration documents to help understand what you're looking at. Because in some instances, a birth certificate is not proof of citizenship. In some instances, a social security card may be proof or may not be. And you want to make sure that your teams fully understand how various documents may be the documents that are necessary to prove what it is that your institution has determined needs to be proved. The next executive order that I'll mention is one that I'm actually not going to spend a lot of time on, in part because I don't know that it surprised a lot of people and that it hasn't really had an impact yet on many institutions. It was issued in August, and I say that because the things that were stated in this executive order were things that I think most institutions were already seeing the agencies doing, and this was just kind of more of a directive saying that this is what agencies should be doing, because we had already started to see senior appointees at agencies taking much more direct roles in grant administration than they had historically. We had already started to see agencies taking action to terminate or discontinue awards that referenced race. And I'm not saying that there was a preference or racial discrimination. We had already just seen actions taken if race had been referenced in these awards, as well as immigration, gender ideology. All of these things had already started to be addressed, and nothing was particularly new, including the preference for lower indirect cost rates. We'd already seen agencies taking actions to try to lower grant recipients' indirect cost rates. So the last item that I think I'll mention before passing on the baton is the presidential memorandum on lobbying and political activity. This was issued also in August. This was late August, though, so August 28th, when the president issued this memo. And in this memo, he asserted that federal law places strict limits on the use of federal grant funds and often prohibits grantees from lobbying with those funds or supporting political candidates or parties with those funds. I think most folks who have grants and have reviewed certifications under those grants are familiar with the Byrd anti-lobbying disclosures and certifications that you make. So that statement probably isn't much of a surprise to you. But then the next one below may be a little bit more of what's impacting what we see today. And that's the direction to the Attorney General to start working with agencies to investigate whether or not grant funds are being used to illegally support lobbying activities, and for the Attorney General to take appropriate enforcement actions. So after that memorandum came out, about a month later, at the end of September, the Department of Education issued a Dear Colleague letter on lobbying. And this letter stated it was a reminder about the restrictions on using grant funds for lobbying activities. But really the focus of it was on recipients' membership organizations. And the gist of that statement was that the use of federal grant dollars to engage in or subsidize lobbying remains strictly prohibited. Excuse me. The letter outlined the Department of Education's views on recipients' responsibilities as related to these organizations and their consequences for violating the lobbying prohibitions. Excuse me. The letter also encouraged grant recipients to consult with their legal and compliance teams to review their expenditures and ensure alignment with the requirements. And we did see a lot of institutions starting to take that encouragement. And part of this was that the agency outlined responsibilities for the grant recipients to state that they had pretty much 5 main responsibilities. The first, ensuring that federal grant money was not used directly or indirectly to pay for lobbying efforts. A statement that membership fees that were tied to a percent of federal grant money were presumed unallowable. Not that they were, but they are presumed. That the third responsibility, that the recipients have to maintain adequate documents to demonstrate compliance, that their membership fees are not used on lobbying, and that their membership fees are reasonable and necessary. They also have a responsibility, according to Ed in this letter, to avoid paying dues to organizations that cannot or do not report the proportion of activities dedicated to lobbying, and also indicating that institutions have a responsibility to request an appropriate breakdown of dues. I list all of these out because they, even though the letter said it was a reminder, the law and the relevant regulations don't actually require recipients to request a breakdown of dues or documents demonstrating that the fees are not used on lobbying from membership organizations. So this really was a new approach from the agency. And it is something that membership organizations were, I think, a bit stunned to receive these requests on. And so schools were, I think, really trying to figure out how best to address this letter, as well as we started to see also schools focusing on the letter from the grant side and not necessarily taking into account some of the First Amendment issues that may arise if they are a public institution, or employment rights that may arise, because we started to see even some schools making blanket prohibitions on lobbying. And so I think once some institutions, I think, maybe overcompensated based on this letter, and hopefully we're going to start to see a move away as all of those things start to get ironed out. But I think that's all from me, and then I'll pass it back over to Brant. And Alex or Scott, is it back to you?
Well, let's see. Right before we get to Alex, we're going to do our first secret word of the day. Remember, you got to hit these secret words to get CLE credit, but please feel free to do it anyway. So today's first secret word is Mary. Please select the correct word below. Mary is C, and once we have a sufficient quorum, we'll keep going. Give you a little bit of time to select the word. For those of you that saw Aaron Lacey's webinar yesterday, first, thank you for sticking with us for 2 webinars in a row. He was talking about his role as a primary negotiator on the AHEAD committee, did one of 2 debriefs, but he was very festively dressed. And so I was seeing this and feeling like I kind of dropped the ball a little bit. But we'll just have to deal with we'll imagine the holiday spirit and be in there. I'll give you guys a little bit, couple more seconds, please lock in those answers. And then we're going to turn over to Alex to run us through the litigation that he's seeing and involved in kind of in Birmingham. All right. Take it away, Alex.
All right. Thank you, Scott. And thank you, Jana. I'm going to try to talk about some grant litigation that's happened during the previous year. As I'm sure everyone here already knows, the administration has ended or tried to end countless grant programs since President Trump was inaugurated. The notices of termination or non-continuation have typically been just 1 or 2 pages and not really given a substantial explanation beyond a reference to the agency or administration's new priorities or to violations of federal civil rights law. As my colleague discussed, President Trump's executive orders about DEI targeted grantees that used certain terms in their grant applications. In some cases, these phrases may have been used in response either to competitive preference priorities that were incorporated into notices inviting grant applications published under the Biden administration that asked applicants to address DEI or DEI initiatives, or to the statement that required all grant applicants to address equity under the General Education Provisions Act. So grant terminations result in the immediate end of funding, and were initially challenged by plaintiffs, and they were broadly successful in federal district courts. Plaintiffs claimed that federal agencies violated the Administrative Procedures Act, which is a statute enacted in 1946 that provides for judicial review of agency actions. The APA waives federal sovereign immunity for actions seeking relief other than money damages, and allows a federal district court to hold unlawful and set aside an agency decision that is arbitrary and capricious, contrary to law, without observance of procedure, or in excess of statutory authorization. And in these grant termination cases, plaintiffs asked the courts to reinstate grant funding pursuant to the terminated grant agreements. And I'm sure, as many of you are aware, the Supreme Court granted the Department of Education's emergency application to stay a district court's injunction that reinstated grant funding. In California versus Department of Education, a group of states sued the department seeking reinstatement of Title III teacher grants. And the Supreme Court ruled that challenges to grant termination likely belong in the Court of Federal Claims under the Tucker Act, rather than in federal district court under the APA. But similar to the APA, the Tucker Act also waives federal sovereign immunity, but it is more limited in scope, and it is directed at claims that arise upon a contract with the federal government. The Court of Federal Claims is limited to awarding money damages, but it can't award injunctive relief or reinstate the terms of a grant. And in California, the Supreme Court stated that a grant is analogous to a contract. After the California decision, plaintiffs continued to sue in federal district court and brought non-APA claims sometimes under the Constitution, alleging violations of the Take Care Clause or Spending Clause. Other courts distinguished the California decision on its facts or due to its status as a shadow docket ruling. Those courts stated that the California opinion had limited precedential value because it wasn't a ruling on the merits. And in a subsequent case, the National Institute of Health terminated grants that were awarded to major research universities. And those universities, states, and organizations sued and were initially successful in district court. The First Circuit Court of Appeals upheld the district court in that case and distinguished California. And in another case, in that case, the government went to the Supreme Court again, and in another application for a stay of the lower court's ruling, the Supreme Court ruled against the plaintiffs and reiterated its ruling in California versus Department of Education. Justice Barrett wrote a concurring opinion that really left open the possibility for a plaintiff to challenge agency rules, guidance, and policies that led up to a grant termination, but stated that any action seeking funding pursuant to a grant must be brought in the Court of Federal Claims. And Justice Gorsuch chastised lower courts for ignoring California and reiterated the need for lower courts to follow Supreme Court precedent, even if the decision only granted interim relief. Nevertheless, courts generally continued to rule for plaintiffs in certain circumstances. Plaintiffs relied on constitutional violations, like Take Care Clause and Spending Clause violations. The DC Circuit limited that practice and relied on an earlier Supreme Court case, Dalton versus Specter, which stated that a plaintiff cannot recast certain statutory claims as constitutional ones in order to avoid statutory limits on judicial review for violations that really are ultimately statutory and not constitutional. Harvard challenged the termination of more than $2 billion in grants and was successful on its First Amendment claims for retaliation and unconstitutional coercion. And other courts have ruled that plaintiffs can maintain claims in federal district court if the plaintiff was not a party to the contract with the government. As in the Kerr versus Trump, the plaintiffs were individual researchers at the University of California, so they weren't parties to the grant agreement in question. Ultimately, California and APHA don't have any substantial reasoning, so lower courts sort of have had to figure it out by themselves. And as an example, the district court in the Harvard case responded to Judge Gorsuch and stated that APA and HA and California were not a model of clarity. So the APA and the Tucker Act both waive federal sovereign immunity, but in different circumstances. The APA is broader and allows for review in federal district court. On the other hand, the Court of Federal Claims is an Article I court. Judges have 15-year term limits, and it's generally seen as more deferential to the government and less plaintiff-friendly, which is likely why plaintiffs would prefer to be in federal district court. While the government has argued repeatedly that the APA doesn't apply in grant termination cases because there's relief available in the Court of Federal Claims, it's not entirely clear how a plaintiff can receive relief, particularly for multi-year grants, because the Court of Federal Claims can't reinstate a grant, which is typically what plaintiffs want. The availability of money damages is, it won't continue the grant, which is really what plaintiffs are seeking. But on the other hand, it really is clear that seeking retrospective relief, which would be money damages, belongs in the Court of Federal Claims. Prospective injunctive relief, on the other hand, is more likely to be successful in federal district court under the APA. A key distinction for purposes of relief is whether a grant was terminated or discontinued or non-continued. Although the effect is similar because a recipient will no longer receive funding, a grant termination ends funding immediately, whereas discontinuation will end funding past the end of the budget period in the grant. Multi-year grants are typically funded by annual appropriations, so an initial grant award that awards the grant will only obligate funding for the first period, even if the grant program operates for something like 5 years. So if an agency discontinues a grant after the first period, or really any subsequent period, the grantee has no contractual right to seek future funding, which would indicate that jurisdiction should lie in federal district court, not the Court of Federal Claims. This was an issue that came up in a recent case in Washington versus Department of Education, where 16 states sued over discontinued mental health grants. The district court ruled in favor of the plaintiffs and distinguished discontinuation from termination. And the Ninth Circuit Court of Appeals recently upheld the district court because vacating the decisions that discontinued the grants would not automatically reinstate grants or continue the grants. For education grants, continuation is subject to regulations that require a grantee to meet certain performance metrics. So although continuation is not competitive, as is the initial grant application process, continuation is not automatic. So this distinction is one possible way of staying in federal district court. Another way of distinguishing California and APHA is through the judicial review provisions of Title VI and Title IX. Both of these statutes apply to any program that receive federal financial assistance. And each statute, Title VI and Title IX are worded almost identically. And each statute expressly creates judicial review under the APA for government actions terminating or refusing to grant or continue financial aid, which is what these decisions would be. And other federal civil rights statutes, such as the Age Discrimination in Employment Act and the Rehabilitation Act of 1973, both have similar judicial review provisions. And the judicial review provision of Title VI was also at issue in Harvard's case to reinstate their grant funding. Harvard had raised Title VI claims with regards to the administration's assertion of anti-Semitism on campus. And the court ruled that Title VI claims were materially different from the contract claims involved in California and APHA, in part because Title VI expressly authorizes judicial review of agency action through the APA. And additionally, because the plaintiffs sought prospective injunctive relief, and that the Justice Barrett's concurring opinion in APHA that discussed the possibility of bifurcating claims between federal district court and the Court of Federal Claims wasn't really possible with the Title VII claim. So my colleague Brant Hill is now going to discuss a few considerations for impacted grantees.
Yeah, thank you, Alex. Hello, everyone. My name is Brant Hill. I am a litigator, a higher education litigator. I've litigated some grants cases this year. And my original plan for today was to get into some more detail on some of the cases that you just heard Alex talk about. But that plan got derailed a couple weeks ago in a grant case that Jana, Alex, and myself are litigating against the Department of Education right now. The judge scheduled an emergency motion for preliminary injunction hearing. That hearing happened on Monday up in federal court in Washington, D.C. And so that sort of ended up interfering with my preparation for today. But I think everyone probably already has a good idea about some of the case law that you've already heard from Alex about. And so I'm just going to try and offer really quickly, with the few minutes left we have here, a few thoughts at a higher level about the types of issues that institutions need to be thinking about after they receive some type of adverse action from an agency with respect to their grant, and how they should respond to that before you get into litigation. So let's say your institution and has a grant, or it's applied for a new grant, and you get a bad letter from the agency saying you're no more grant. What should you do? Well, there's a list here. I've got them on the screen in no particular order. But the one thing you should do right away is just understand what type of grant is this. Is this a discretionary grant, or is this a formula grant? And that's important because the authority that the federal agency has to deny a grant and the remedies that you may have because of that denial are different depending on whether it's a discretionary grant or a formula grant. I'm sure many people listening are well aware of the distinction between a discretionary grant and a formula grant. A discretionary grant, by definition, gives the agency some leeway when it comes to selecting who's going to get that grant and how much that grant will be for. Formula grants, on the other hand, give agencies very little discretion. So there is a significant difference, and it's going to be more difficult if you have a discretionary grant that is lost to get relief. But all is not lost. You absolutely still can seek relief And, the term discretionary grants is really a broad term, and it doesn't mean that agencies have discretion to just do whatever they want and award grants to whoever they choose. It doesn't mean that the Secretary of Education can say, I'm going to award a grant to this institution because I root for that school's football team. That's not how it works. The agencies still have to, of course, follow the laws. And most of the litigation that Alex has talked about and that you've heard about today has all been around discretionary grants. And in many cases, the government has been found to have abused its discretion. And so the point is, don't assume that just because you have a discretionary grant and you've lost it, that you are without recourse. A second important thing you need to figure out is, what is the length of this grant? Most discretionary grants are awarded for a multi-year period, maybe 3 years, 5 years, even longer. But really what is critical is understanding the period of time that the government agency has obligated or committed federal funds to you. And that's important because that is going to determine how you can get relief, what type of relief you can get, and where you can get that relief. And this really goes to the third issue I have here on the screen, which is you need to figure out the type of agency decision that is made on your grant. Did you have a application for a new grant that was denied? Did you have an existing grant that was terminated? Or did you have an existing grant that was discontinued or suspended? These are all terms of art. Different legal consequences flow from each of these actions. And at a high level, looking at it from 50,000 feet, you think you lose a grant, it's all the same, but it's really not. These are distinct actions, and you need to understand them to know how you can take your next steps. The fourth thing is you've got to understand the agency's reasons for ending your grant. We've talked a lot about agencies coming in. The new president has new priorities and new policies. That's, of course, to be expected. That's what happens when a new president takes over the White House. But there are still constraints on agencies' ability to do that. The main constraint being the concept of notice. If an agency has to inform grant recipients of their new rules before they just yank their grants. And that is why we have been in so much litigation over grants in 2025. Now, fifth, I know we're almost running out of time here, but this is very important. If you get a letter denying your grant, quickly figure out what opportunities you have to seek reconsideration or appeal that decision before the agency itself. That is important because if you end up down the road in litigation, you do not want the agency to be able to argue that you waived your right to seek relief by not going through that review process before the agency. That is an argument that has been recurring. It has come up, and just because you don't know if you'll end up in litigation 6 months, 1 year down the road, you want to preserve your ability to do that and get that reconsideration or appeal request on file. There is typically a deadline to do so. It depends by agency. Many Department of Education grants have either a 7 or a 30-day deadline. So that is one of the first steps you want to take when you receive a letter. And I'm just going to quickly, I'm going to skip number 6. I'm going to go to number 7. If you are considering bringing litigation because of your lost grant, before you go at it alone, before you file a lawsuit against the federal government as a solo institution, think about if there are other institutions in your same position. It is much easier to fight the federal government when you are with other institutions by your side. Many states have taken collective action on behalf of public institutions in their states that have lost grants. Your institution may be a member of an organization that would be willing to seek relief on your behalf. And so Again, when you go up against the federal government, it will fight tooth and nail to not spend your money towards grants, and it's much easier to do it together. And then very finally, and I know we just have a minute here. Well, you know what? It's 3 o'clock. I want to give a minute for questions. So, Scott, I'll pass it back to you, and we go from there.
Thank you, Brent. Appreciate that lightning round. First, I want to get to that the second secret word, right? I want to make sure if you're here for CLE credit, please make sure to hit this button, right? The second secret word is bright. Letter A, please select bright below. We'll give you a minute to do that. We'll stay a little later for questions. Hopefully we can get to a few. I know we were trying to put together this presentation. We were always thinking, should we do an hour and a half, an hour? And people usually like the shorter ones, but we should have known there's too many things to talk about here. So we'll stay on. We'll try and answer some questions. Please submit this. I will leave this on the screen. I'll preview what I'm about to click through is our TC extra credit, right? Just our blog and post things there on our website. Please, you're most welcome to find it. And then I'll leave our disclaimer on the screen, right? This is for informational purposes only. We're not your lawyer unless we are your lawyer. And so, Jane, I'm going to hit the first question to you just in lieu of time as I go through the slides. Can you walk us through the lobbying discussion that you had, right? Does that mean institutions use grant funds for purchasing memberships, or can you give a little more color to that discussion that you had toward the end of your presentation?
Yeah, excuse me. Yes, it does. The 2 CFR guidance that most agencies have adopted for purposes of their grants does allow grant recipients to use their grant funds to pay for membership in various organizations. It does have to be, it does have to meet the other requirements to be an allowable cost. So it does still need to be an allowable cost allocable to the grant and a reasonable cost in general. But it is something that we see institutions doing either as a direct or oftentimes as an indirect cost. The membership fees may be included in one of the indirect cost pools.
Awesome. Thank you, Jana. Again, we'll try and go through a couple of these here. So there's been, I guess, a question about front loading, right? Can someone explain what front loading means and how that applies here and what institutions consider it in the context of grants? And that's open to anyone.
Alex or Brant, I'll let you take first dibs.
Don't all jump in at once, right?
Yeah, I'll talk about front loading. Front loading is a unique concept that has not come up very often until this year, at least as far as I'm aware. Basically, what happens when an agency front loads a grant is that it takes money from a particular fiscal year appropriation and it allocates it to a grantee and says, here's this money, but you can't use it until a future year. So this summer, for example, the Department of Education has taken funds from fiscal year 2025 appropriations and gave that money to grantees, but said you can't touch it until 2026, 2027, that academic year. And that's a unique practice. We haven't seen it very often. The Department of Education's own handbook and guidance material describe it as something that should be avoided at all costs possible. And there are various reasons why the department may be doing that. And I don't want to speculate too much here on this call, but generally it's a bit of an accounting trick that the department has employed to say that it is spending money that Congress has appropriated to it, but not actually spending it until future years. So if that happens to you, that's a unique situation, and you should certainly seek advice from your counsel about that, because there are various implications due to it. Hey, Jana, was that like an okay explanation? It's a complicated concept.
It was perfect.
Thank you.
Well done, Brant. And we're over time. There's a couple questions, right? Last one for the group. And so I guess basically, yes, we know 2025 has been unpredictable, roller coaster, right? Unprecedented. What do you see on par for 2026, right? More of the same. And this is again, we're not going to hold you to it, but put on your use your crystal ball or your prognosticator hat. What can institutions be on the lookout for 2026? Anything changed or a lot more of the same?
So I'll go ahead and start. And yes, 2025 has been the busiest year in terms of federal grant litigation, I think probably on record. There have been more decisions by federal courts in grant cases in 2025 alone than there were over the last 25 years. The courts are digging up old cases from the 1970s and 80s as a reference to figure out how to deal with the kinds of issues that are arising today. And it's an enormously complex and fast-changing environment, and that alone should lead all programs, if you receive some type of adverse letter, to seek advice of your counsel. But in 2026, my sense is that the federal government is going to maybe slowly start focusing grant terminations and discontinuations and denials less on ideological reasons surrounding race and DEI and all this, because that has gotten the administration in a lot of trouble in the courts. Yes, it has won some cases, but I think that this administration probably did not expect the avalanche of litigation that it has had to deal with this year. And so I would expect in the next grant cycle, next year and the year after that, for more grants will continue probably to be denied and whatnot, but it will more likely be based on performance-based reasons that are somewhat more defensible than pure ideological reasons.
Interesting thought. Jane or Alex, any other thoughts? Or does Brant get the last word?
I'll give Brant the last word.
All right. It's very kind, very gracious of you.
Very gracious.
So with that, we're over time. Thank you to Jana, Alex, and Brant for walking us through a lot of complicated material. Thank you guys for sticking with us for overtime. If you do have any questions regarding this, we're here to help. And if we don't talk to you then, be well. Happy holidays.